Hello, my name is Austin Gilly, and my fatherhood is on trial with AI. By this point in the series, you've seen the divorce filed, my children cut off from me, a court appointed therapist installed as gatekeeper, a ruling that split the case in two with custody and visitation delayed. The first scheduled trial was delayed to try to block a clinical psychologist from testifying. The second custody trial was delayed because the court's own therapist would not participate. And on January 22nd, 2026, the judge required her to cooperate over the objections of her own law firm, whose entry made a total of 7 lawyers now officially involved in this case. In this step, we will review what happened on this side of the now split case. I want to be clear that we are all under a gag order not to talk about the court therapist's report on the children, and the judge promised to sentence to incarceration anyone who he found in contempt for doing that. I respect that he is trying to protect our children, and as I have always tried to balance transparency and discretion, I will do the same. I have asked Claude not to present anything directly about my kids, but the process, comments about me and Mom, deserve transparency to hold accountable a public process that in my view has miserably failed the very children it is trying to protect. For instance, the court's therapist has never issued a report, and, as you will see in a moment, she never completed any assessment. In 2023, the judge ordered the therapist to perform some clearly spelled out tasks that you can see here. The judge also said that I could not see my children without her permission. On April 1st, 2026, my attorney took her 195-page deposition, and Claude has analyzed all of it. The evidence shows that in more than 2 years and over $26,000 in billings, with more being sought, nothing was accomplished. My attorney asked her point by point what she had done. My attorney asked about the treatment plan. Did you do that? Her answer was, not yet. He asked about the risk assessment. She said she had begun both of those in draft form, but had not disseminated them. Then he asked about the barriers in writing, the substantive content of what reunification therapy is actually about, the problem the therapy is supposed to identify and address. My attorney pointed her to her own court update letter, where she had written that the parties' barriers had been identified. He asked, did you articulate those barriers anywhere in writing? Her answer was, we didn't get that far. Claude analyzed and categorized all of the billed hours from 2023 to April 2026. The therapist spent more time on administrative tasks and writing letters than working with her patient. My attorney also asked her about the procedure for updating the court. The 2023 order said her progress reports were to go to counsel. Why had she sent her letters directly to the judge? Her answer was, I just assumed that's what that was. That assumption is what created the public record at the heart of the gag order argument I described a moment ago. At the end of the deposition, my attorney put it simply that she didn't get very far in what she was ordered to do. She simply nodded her head and said, correct. The reason she provided was me. I was to blame for, quote, fighting the process. So I asked Claude to review the evidence of whether that characterization is supported by what was actually happening during that period. By September 2024, the therapist's office had been dormant on my side for about a year. The case itself had been dormant on the children's side for months. I paid down the outstanding balance with donations in spring 2024, and our office began scheduling again. I made the decision to record my next 2 sessions with her, the first on September 25th, 2024, and the second on January 8th, 2025. These were not clinical sessions and did not include my children. The only sessions in which my children and I were ever in the same room, virtually, with her were the ground rules meetings in 2023, which are disputed in the record as to how much talking I was allowed to do, and where my single "I love you" greeting in the first meeting is what set off the controversy I referenced previously. She never observed how my children and I actually relate. I recorded these sessions because despite repeated written requests, the documentation the court had ordered her to produce was not being produced. I needed a contemporaneous record of what was being said. Her own office labeled these meeting updates, as did her invoice and her later sworn deposition. I want to be open about these recordings because, as Claude has noted, the framing of me as the problem has run as a thread through the case from my father-in-law's very first confrontation all the way forward to now. These recordings cut both ways, and I am content to let Claude, the real judge, and anyone who hears them judge for themselves. I asked her directly about the framing that my contact with the children had stopped because of me. Across the two recordings, here is how that went. She didn't recall writing that I was backsliding by not paying. She claimed we both agreed to end visits, but Mom's own correspondence doesn't match. And then she validated the approach of spending money on therapy. Between November 2024 and January 2025, I sent 8 substantive emails to the therapist's office after they instructed me to email instead of texting. None received a written response. When I asked her about that during the January 2025 recording, she told me her process was not to respond to substantive emails, that they were kicked over into paperwork review whenever she marks out the time to sit down and review stuff. We ended the call with my seeking another meeting to discuss those emails. She never called me back. 2 months later, she spent 27 hours over 7 days drafting another letter to the court. In it, she referenced events I had already told her about directly, but framed them as items she had discussed with my attorney and intended to discuss with me without acknowledging that I had already raised them with her. When she sent the bill for that letter and the sessions she'd had with Mom and the kids in the same period, it was $8,850. By that point, garnishments had taken effect. I no longer had the ability to redirect any of my support payments toward the therapy the children needed. The work that had restarted with my donations stopped again. There would be no more sessions, and nothing with her until her deposition 15 months later in April of 2026. Also not included in that March letter to the court were the things she said under oath about the mother. In her deposition, she described the children as enmeshed and even somewhat fused with their mother, and described the mother's own insecurities and fears as having become involved with the children. None of that appears in the letter she sent the court. The letter instead called the mother fully cooperative and her behaviors overprotective and not malignant. By her own testimony, her adverse conclusions about me came from brief, rule-setting meetings before the assessment she was ordered to complete was ever finished. That's where the clinical work ended, but the case kept moving. I couldn't pay, and opposing counsel would not execute what the judge ordered in February. Both sides traded motions to debate the terms, requiring an order to clarify the order. Then finally, the judge ordered the decree signed on August 7, 2025. At the same time, the pretrial order was issued for the custody trial in November. In preparation, my attorney began seeking the court therapist's testimony for trial. He emailed her directly on September 12, 2025. He sent a subpoena by certified mail on September 24th. On September 26, she had legal representation. 2 of their attorneys entered an appearance. They wrote my attorney to say service was improper, that the therapist was now represented by them, and that all further communication should be directed to their firm. 11 days later, that law firm withdrew. The financial divorce order from February 2025, with the forced acceptance 6 months later, would still not be executed for another 6 months, 1 full year after court ordered, keeping all money tied up. After the therapist's first law firm withdrew, my attorney sent a new subpoena. The certified mail came back unclaimed. He still proceeded to notice her deposition. On the day it was supposed to happen, she did not appear. A court reporter certified her non-appearance. Recall the original order of the court for her role as therapist was to work with and cooperate with the attorneys. The November trial date was now weeks away. With the court-appointed therapist refusing to participate, my attorney filed for a continuance. The trial was stricken, delayed once again. In December, she had new legal representation, a different firm. My attorney filed a motion asking the judge to require participation. On January 22, 2026, the judge heard arguments, and that's where we opened this step. At that hearing, the court took up motions from both sides. My attorney had moved to require the court-appointed therapist to appear. Opposing counsel had moved again for the court to require me to pay Mom's attorney's fees, and again for the judge to interview the children in chambers without the lawyers present. The court ordered the deposition would happen, with 3 conditions. A new intake packet had to be completed, the questioning would be limited to issues from this case only, and she had to be paid. Everything else was taken under advisement. In the following weeks, 2 official records about me were corrected. On February 19th, the state's child support enforcement attorney confirmed in writing that my child support record had been wrong. My passport renewal had been denied, my tax return diverted, on the basis of arrears that did not, in fact, exist. Once spousal payments I'd made were properly credited, I was not behind. I was overpaid, and they were sending a refund. This was very good news because the contempt citations against me had all been built on the state's arrears record. On February 23rd, I completed the new intake packet the court had ordered. It was the 4th one. On February 27th, the court issued a correction to the January 22nd docket minute. The minute had said the in-camera motion to interview the kids privately was sustained or granted. That was not what the judge had ruled. I had flagged the discrepancy with my attorney, and the minute was corrected to say what the judge had actually said, taken under advisement. Another issue delayed again, a trial date still to be determined. On March 17th, the court issued its formal order. Ironically, the deposition was to happen by March 15th. That didn't happen, but 3 conditions did. I had to sign the 4th intake packet, and I had to make payment to her in accordance with the payment structure those packets specified, which included prepayment of a $5,000 fee and her preparation time for the deposition to cooperate with the attorneys she originally was ordered to do. On April 1st, the court-appointed therapist was deposed at her attorney's office. On April 7th, her attorney moved to add an unpaid invoice from over a year earlier, more than $7,000 more to the case record. By April 15th, that old amount had been consolidated along with another deferred invoice and the new deposition preparation charges into a single new invoice that they now expect me to pay. Clarification is still pending and likely won't get resolved until trial. What remains in dispute is custody and the children's medical care. Since 2022, the court has given Mom final decision-making authority over their health. I receive the bills for treatments I was never consulted on, or when I ask about a diagnosis or a protocol, I'm only reminded of that authority. A licensed clinical psychologist had already given the court a report documenting emotional harm in the household. Even the mother's own chosen therapist had recommended a psychological evaluation. It was declined for cost, but in the same period, a $5,000 genetic test for medication management was pursued instead. Mom also decided to remove one of our children from school, overruling mine and the guardian ad litem's recommendation. Mom cited health issues were causing our child to miss too much school. Even though Mom's own clinician documented that there was no basis for missing school. I am completely cut out of these decisions by the authority of the court and its therapist without due process. I can only watch and pay and wonder. So in March, I wrote to my children directly on GoFundMe, not about the case, about them. I told them they are growing into people who can think for themselves, that they're allowed to ask questions about their own health and the choices being made for them, that they can, in fact, say no, that love does not require silence. They can love everyone in their lives and still trust their own instincts, and to hold on to hope. That brings us all the way up to today. What now is in the best interest of our 4 children? The lines are now drawn. Mom says it's dad, and dad must pay. Dad says it's mom. The court asked mom to cooperate. Mom said the therapist decided. The court said the therapist decides contact. The therapist said to make dad pay for it. Dad tells the therapist it's mom, and the therapist says dad must pay. Meanwhile, 2 of our children in the system is supposed to protect, are aging out of it as time passes. Mom tells the therapist it's dad, and the therapist says the process just got started and dad must pay. The court says dad must pay. Dad can't pay. And they have all had lawyers and family and experts to assist. The result of this machine is 5 years of childhoods lost and parent-child bonds destroyed for no reason. What do we do now? Next, Claude will begin its judgment.